In this part 20, as far as our series of lectures is concerned, we will try to understand processes to compel appearance of a person in a court of law. And to understand this, we shall refer to chapter 6 as far as Criminal Procedure Code is concerned. And in order to understand chapter 6 of the Criminal Procedure Code, we shall be starting right from section 61 up to section 90 of the Criminal Procedure Code. Before we deal with this chapter, it is essential for us to understand as to why it is necessary for a court to compel appearance of a person in court of law, and whose presence in court of law is must, which is necessary, and hence court has got power, court has got sanction to compel appearance of such a person in a court of law. Maybe during the course of an inquiry or the trial, the person against whom the inquiry is conducted or the trial is conducted, accused person, his presence is must in a court of law. In order to observe the principles of natural justice, because every person has got right to hear and to be heard. Whatever evidence is recorded which is against him is required to be recorded in his presence, and he has got right of what is known as cross-examination. In order to exercise this right, the evidence must be recorded in his presence, and hence if a person at the time becomes a person of unsound mind, then that inquiry or the trial is likely to be adjourned or postponed, and hence during course of time, when we shall be dealing right from section 328 up to section 339 of the Criminal Procedure Code, and the heading of the chapter is provisions regarding accused person of unsound mind. So he is, in this case, he is understanding everything which is going on in a court of law, but in order that his appearance should be made compulsory, or he should be compelled to appear in a court of law, what are the steps that can be taken by the court of law? There may be witness on behalf of the prosecution, there may be witness on behalf of the defense, or there may be what is known as court witness as far as section 311 of the Criminal Procedure Code is concerned. In order to compel all these persons in a court of law, which is must from the point of view of administration of justice within the country, the importance of this chapter. Now, what are the ways, or what are the different methods that are followed by the court of law so that it is possible for the court to compel appearance of a person in court of law? As we start reading, for the purpose of understanding, broadly the ways can be enumerated as follows. 1. Court has got power to issue what is known as a summons. 2. If that doesn't serve the purpose, court can go to the extent of issuing what is known as a warrant, which may be bailable warrant or non-bailable warrant. If that cannot be executed, then the court has got power to publish what is known as proclamation. And if the proclamation doesn't serve the purpose, court can go to the extent of passing an order to attach his movable as well as immovable property. So these are the measures that can be taken by the court of law with which we are going to deal as far as this particular chapter, namely processes to compel appearance of a person in court of law is concerned. Now, in order to understand summons, we shall start right from section 61 up to section 90 of the Criminal Procedure Code. at the time of understanding the provisions regarding summons, the first thing that we shall take into consideration as to what do you mean by valid summons, for which we have to read and try to understand the ingredients or essentials to constitute a valid summons as far as section 61 of the Criminal Procedure Code is concerned. Once we understand what is valid summons, then the next time it can be said that the summons was properly served. Summons was duly served, for which we shall be dealing right from section 62 onwards, and during course of our lecture we shall be learning as to what do you mean by personal service of the summons, what do you mean by extended service of the summons, and what do you mean by substituted service of summons. We shall also try to understand that there can be a summons with respect to a corporate body, or there can be a summons with respect to a person who is a government servant. There may be possibility that the summons is required to be served beyond the jurisdiction of the court which has issued it. What is the procedure? And hence rest of the details with which we shall be dealing right from section 61 up to section 69 as far as summons is concerned. In order to understand provisions regarding warrant, we shall start discussing right from section 70 up to section 81, where we shall be taking into consideration what do you mean by valid warrant, warrant can be issued to whom, it is addressed to whom, how the warrant is executed, where it is executed, can there be execution of the warrant beyond the territorial limits of India, and what is the procedure, rest of what is the distinction between valuable of warrant and non-valuable warrant, how long the warrant can remain in force. All these aspects shall be taken into consideration when we deal with this particular part as far as this chapter of the Criminal Procedure Code is concerned. In spite of the fact that the warrant is issued by the court of law, if the person doesn't remain, is not cannot be, could not compel his appearance in a court of law, as per section 82 of the Criminal Procedure Code, there is a provision where the court will publish proclamation. Now, how it can be published, where it can be published, what is mandatory, and all these details with which we shall be dealing as far as section 82 of this chapter is concerned. In spite of the fact that there was publication of proclamation, and as per the date which was mentioned in the proclamation, the person doesn't remain present in a court of law, court can go to the extent of passing an order as per section 83 of the Criminal Procedure Code, namely attachment of the property which is inclusive of movable as well as immovable property. During course of our lecture, then right from section 84 up to section 86 we shall be dealing with different provisions as to if the property is attached and somebody has objection, what is the manner in which the objection is required to be raised, what is the procedure that is followed with which we shall be dealing, and then right from section 81 up to section 90 are the sections which are general rules regarding this particular chapter with which we shall be dealing during course of our lecture. Now, the reason why I have sort of an introduction to this chapter with which we shall be dealing in detail as far as next part is concerned is very simple as usual, and that is, if you read right from section 61 up to section 90, that will definitely serve the purpose from the point of view of understanding as to what do you mean by summons, what do you mean by warrant, what do you mean by proclamation, and what do you mean by attachment of the property. This is also the time for me to remind you as to the importance that was told by me as far as second schedule of the Criminal Procedure Code is concerned. While you read right from section 61 up to section 69 for the purpose of understanding summons, do read form number 1, form number 30 and form number 33 as far as second schedule of the Criminal Procedure Code is concerned. When we shall be dealing with warrant, I want you to read right from section 70 up to 81, along with form number 2 and form number 9 of the second schedule of the Criminal Procedure Code. When you read proclamation and try to understand as to what do you mean by proclamation, and to understand proclamation in detail, this is the time for you to read form number 5 and form number 6 of the second schedule. And when you want to understand everything regarding attachment of the property, which is inclusive of movable as well as immovable property, you have to read form number 6, form number 7 and form number 8, which will serve the purpose from the point of view of having clarity regarding understanding of the topic with which we shall be dealing during course as far as our series of lectures is concerned.